Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So without any further ado, it is my great pleasure to introduce our panelists today. Starting with Judge Steve Austin. Judge Austin joined ADR Services, Inc. in 2022 after a distinguished 23 years of judicial service as judge of the Superior Court for the County of Contra Costa. For 13 of those years, Judge Austin managed a busy civil direct assignment caseload, where he was responsible for all case management, law in motion, discovery, settlement conferences, and trials. He became widely renowned for proactively and successfully settling his cases and conducted close to 1,000 settlement conferences over the course of his judicial career. In addition, Judge Austin was deeply involved in court leadership and worked tirelessly to promote better access to the court system for the underserved. Now he's a neutral mediator, arbitrator, and referee, and his approachable personality and intellect allow him to appreciate the complexities and subtleties of each case before him. And he strives to view everyone as a person rather than a problem, adding a humanizing element to each matter he handles. And I always make him blush by reading off this intro. Next, we have Debra Bogaards. Debra is a seasoned mediator with, goodness, this is out of date, over 5 years of private mediation experience, but you have more now. Almost 30 years as a mandatory settlement conference officer in San Francisco and Marin counties. She holds a remarkable track record of a consistent settlement record of over 98%. Having gained a balanced perspective after representing both plaintiffs and defendants throughout her 40-year career, her expertise includes a wide range of employment issues, personal matter, injury matters, elder neglect and abuse, and landlord-tenant disputes. Debra is known for her warm yet direct approach, combining compassion with a no-nonsense attitude. And renowned as a quick study in mediation, her success really hinges on meticulous pre-mediation preparation and commitment to ongoing support, ensuring resolution even if it doesn't resolve at the initial hearing. So thanks for being here today, Debra.
Maybe.
And our guest speaker today is John Dean. John earned his AB from UC Berkeley and his JD from UC Hastings, which is now UC Law San Francisco. He is admitted to practice in California and the District of Columbia. And after working as a criminal defense attorney in the corporate sector, John joined the Airline Pilots Association International, ALPA, in 1998. Over 18 years, he served in various roles there, most recently as Senior Labor Relations Counsel, assisting pilots in collective bargaining, contract enforcement, mediation, arbitration, and regulatory proceedings. And he left the ALPA in 2016. Then since 2007, John's been an adjunct professor at UC Law San Francisco, teaching negotiation. He received the 2024 Mary Kay Kane Distinguished Teaching Award. He also lectures on negotiation, ethics, and dispute resolution. And as a mediator and arbitrator, he focuses on labor and employment disputes. And he also serves as a judge pro tem and a settlement conference officer for several Bay Area superior courts. Thanks so much for lending your expertise to our program today, John. It's a pleasure to have you.
Thank you.
So I will go ahead and pull up our slides. And for everybody watching, I'll put a link to the materials in the chat section in just a moment here. I will hand it over to Debra, or Judge Austin, excuse me, who had our first section today. First, I'll give it to John and Debra, who are going to say a quick word about the CNDR, who is partnering with us to put on this presentation this afternoon.
Okay, I'll jump in here. CNDR was founded in 2004, and the idea was to provide law students and practicing attorneys and mediators and arbitrators with a source for learning about the negotiation process and ADR process. We have a very robust and diverse faculty, primarily adjuncts, so it's practitioners from the community, both active neutrals and practitioners in a variety of areas, in-house attorneys and private law firm attorneys. We provide negotiation and ADR training for students. Students are provided a range of externships within the community. We provide CE programs for practicing attorneys and a very active international training program for international neutrals. It's a pleasure to be here, and a special shout out to Katie and the staff at ADR for putting this program together.
And just one little note. So I met Professor Dean when I shadowed his class to teach negotiation. I'm now in my 4th semester teaching negotiation at UC Law SF, which is for 2Ls and 3Ls and master's programs. So it's a pleasure to be here in this program.
Okay, then I think I'm the first up, right, Katie?
Yes, you are. Take it away.
All right. Well, welcome everybody. It's an honor to be here today to make this presentation, especially given who I'm presenting with. Debra and I go back a long way. I'm not going to tell you what year, but we were in the same class at what was then Hastings, now UC Law San Francisco, a few years back. And so we were there together. I've known her through the practice, and now we both work together at ADR Services. So it's nice to be with her, and it's been wonderful getting to know John as we prepared for this presentation. As you heard, I was a judge for 23 years, and I did civil practice, the civil department, just about all of that time. And in that capacity, I lived both as a time when I was an attorney before I was a judge, with the rules of professional conduct, and then as a judge, I lived with the canons of ethics. Really detailed, both sets are very detailed. The canons of ethics even more detailed. We had a whole book by Rothman that was like our Bible on the bench. It talked about all the ethical requirements you have when you're doing that job. So I'm kind of sort of embedded in me that I have those and whatever I'm doing. And so when I started this new job as being a mediator and a neutral, I looked into right away, well, what are my ethical requirements as a mediator? And it didn't take long to figure out that really the structure is not there like it was when I was both as a practicing attorney servicing clients and as a judge. There really aren't that many rules or canons that apply directly to mediators in their role as a mediator. But there are some, and that's what we're going to talk about today. What's the ethics from the mediator standpoint? What is the ethics that apply to a mediator, both in terms of conducting the mediation, and we're going to talk about confidentiality too, and privilege, the mediation privilege, and that also implicates the mediator's ethical duties as well. There are some good guidelines for mediator ethics. And before you can move it over, but I just talked about one of the areas of guidelines. The ABA Model Standards of Conduct for Mediators. It was developed about 20 years ago. It's really good. It's a good place to check in. I'm not going to be talking about all the different standards. There's quite a few, but it's a good place if you're a mediator, or even if you're thinking that the mediator maybe cross the line, isn't doing something. If you're a practicing attorney, it's good to take a look at those, and it never hurts to remind a mediator if that maybe they should not be doing something that you think isn't ethical. It's okay. We all learn, and we don't. We develop our own things going. Just like when I was a judge, I kind of liked it if people told me they thought I was doing something I shouldn't be doing, so that I could take the time to re-examine that. So for you practicing attorneys, I don't think that it would cause a mediator any problems if you pointed out things that you think the mediator is doing that may not be up to snuff in terms of ethics, because most of us appreciate knowing it. One place that there are some rules that apply, not necessarily completely to mediators, but there's a couple in the rules of professional conduct that apply, I think, squarely to a mediator. But some that I think are general enough so they do apply. Rule 1.1, which is the competence rule, is the one that comes to mind first, and that's what we have up on the screen. Under that, so if you take it as a mediator that's an attorney, and again, this would only apply to mediators that are attorneys. The rules of professional conduct don't apply to mediators who aren't attorneys, and there are not that many of them, but there are out there. Rule 1.1 would say, if you applied it to a mediator, that a mediator attorney can't intentionally or recklessly or with gross negligence perform his or her job as a mediator. You also can't just be incompetent at your job over and over again, which is where it says that you can't be repeatedly fail to perform your legal services with competence. So that's, I think, a good baseline. The notes talk about more as what is meant by competence. And there's a definition, and then in the notes itself, there also is some discussion of what happens if the lawyer has to have sufficient skill and learning in the topics that are presented for them to provide the legal services. And I think that applies as well to a mediator. Sometimes you get cases, and I know I've gotten cases that I don't really feel like I know enough about that area of the law to be a functioning mediator. And so I've turned them down. I've said, no, somebody else should be doing this. SEC regulation, a lot of corporate taxation things. I've had a couple of those come my way. Maritime law. You'd be surprised how many things pop up. When you're a judge, you kind of get stuck. You have to do them. But as a mediator, not necessarily. So, and when sometimes there'll just be topics where I don't really know for sure the factual background or some scientific issues, and I try to get up to speed on those if at all possible. And I ask the attorneys who are participating in the mediation if they could give me a little more information on any kind of technical aspects that are present. That's completely consistent as well with there was an update to the definition of competence to include, this was in 2021, to include the duty to keep abreast of changes in the law and its practice, and this is the change, including the benefits and risks associated with relevant technology. So all attorneys have to do that, and attorney mediators have to do that as well. It doesn't just mean that you have to, I think as a mediator, it probably doesn't apply to just making sure you got the Zoom screen working right during your mediations, which you'd think after five years of doing it now since COVID, I'd know how to do that, but I still foul it up. So it's not that. I think it's more broad. If there's, especially if you get cases as a mediator that have to do with tech issues, it's important that you're up to speed and that you understand what those issues are. E-discovery stuff comes around, and there's issues with that. And it's important that if that's going to be an issue in the mediation, that the mediator, I think, ethically has a responsibility to make sure that they know enough to be able to function as a competent mediator. Okay, we can go to the next one. Rule 2.4 is one that does directly apply to third-party neutrals and mediators. That's when you have a self-represented litigant that is involved in the case. You got to make sure that the person understands that your role as a mediator is not as somebody to give them advice or not somebody who's representing that person. I spend a great deal of time when I'm having self-representing litigants and in my mediations to make sure that they understand that and they understand my role. And not only that, but that they understand that I'm there to be equally neutral to both sides. A lot of times I've found with self-represented litigants that they get suspicious of the process because of the fact that there's always an attorney in the other room. They know I was a judge and I'm an attorney, and they kind of think all of us lawyers band together sometimes. And I try to make it clear that that's not going to happen in this case, that I'm there for both of them. I'm there to be the neutral that listens and is going to not take sides in the case and just try to see what I could do to help them form a settlement. As to the disclosure issue, we have at ADR Services, and I think a lot of the other mediation services have a form that gets filled out in order to comply with this rule. And it's great. I go through that form with the self-represented litigant talking about what my role is. And I think it works really well. It brings up the topic and it allows the mediator to have some protection at the end too, because they end up signing that they understand that. So I think it's a good thing both to remind me of my ethical responsibilities and also to protect the process. All of you by now are familiar with Rule 8.3 that came in a couple of years ago that has to do with reporting usually to the state farm or the state bar or to some other tribunal when a lawyer knows of credible evidence that another lawyer has, and it's all down here, committed a criminal act or engaged in some other kind of bad conduct that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer. It's a difficult thing that I think all of you in your practice are going through right now. What that means, what it means to have to report. When the rule came in, it didn't have an exception in it at all for mediators. Which makes it difficult when you're dealing with a situation where the mediator may learn of the issue that may require reporting, but learned about it in a confidential setting during the course of the mediation. Interestingly, the rule still as written does not exclude arbitrators who would have the reporting requirement under 8.3. But, and if we move to the next slide, the rule, although as originally written, did not exclude mediation. I think a lot of the mediators and mediation services got together and pointed out what the problems with that is because of confidentiality during the mediation itself. And so we were written out. So it doesn't apply to information that's protected by the mediation confidentiality. And you hear all kinds of things in mediation, let me just tell you. So it's important. It's an important thing that rule is there, I think, just to protect the process. There's a note on this slide, though, in the green there. It's not a blanket protection for mediators. The mediators don't have to follow 8.3. They just don't have to do it if the information is protected by the mediation confidentiality provisions. So if you learned it during the course of the protected aspects of mediation, where things are confidential. But you may learn of things, and I'm going to talk about a couple of things later, where you may learn of outside of the matters that are protected by confidentiality. Before maybe it happened before the mediation started. Maybe it happens after the mediation's concluded. There are ways that you can end up still learning information that may have to be required to be disclosed. 8.4, that's the general misconduct provision. It includes that any attorney is professionally guilty of misconduct if they engage in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation. This one doesn't exclude mediators. I think anybody who's an attorney, this would apply to. And particularly it applies to a violation not only in your service as a lawyer, but also outside of your practicing of law or acting in a professional capacity. When I was a judge, you'd see it sometimes, and lawyers who ended up not behaving the best in connection with their divorce. That was like the #1 place you saw this one, where they might not have been all the way truthful when the heat of the emotions of that event had to take place. But you see it in other ways. When on the bench, I'd see it, and you could see it sometimes every once in a while. I've had some mediations where people get close to it. I've had a couple of probate ones where you can be with a lawyer who was a party and fighting with family members, and there's heights of emotion, and things can happen in that setting that could cause you to walk over that line. So even it could happen to a mediator too, when things get highly emotional. Let's go on the next one. There are a substantial number of rules that apply to court-connected mediations, which is a little bit different than what I do every day. Debra, I don't know, are you on any of those court mediation panels? I heard that John is. But we've had them in Contra Costa County for forever, and they're very, very successful, and people sign up and they have to go through some trainings, and you end up being on that panel and you get referred arbitration cases. Contra Costa, it's the first 4 hours are free. It used to be they'd come into court and do it. Now it's all on Zoom at different times. But if you're in one of those programs, the court-affiliated mediation programs, there are a series of rules of court starting at 3.850 that apply, and they provide pretty specific requirements that aren't found in other places. They're similar to the ABA guidelines in a lot of respects. But I think some of the mediators, and I know a lot of the parties who participate in these, aren't really aware of them. So I'm going to go through a couple of those. So why don't we move on to the next slide? The provisions provide that there should be a voluntary mediation warning. What that is to tell all the participants at the beginning, the mediator is required to make sure that they know this is all voluntary. If you want to stop, you can stop and leave. You don't have to. I'm not here making anybody to do anything or holding anybody's feet to the fire. You're here to try to see if you could resolve the case, but it's a voluntary process. You have to explain mediation confidentiality to the parties so that they understand that everything being said is confidential, and they're not going to be able to use anything that they learn here against the other side in any kind of litigation later if the case doesn't settle. You have to observe caucus-specific confidentiality. So in most of my mediations now, and I think most everywhere, people are broken up into separate breakout rooms, and the mediator goes from room to room. And the caucus-specific confidentiality is if one party tells you something in confidence during that time that you can't share that with the other side. And you have to explain that, and the mediators have to observe that during the process. This reminded me anyway, and I talked a little bit to the panel before, of difficulties that I'm having with my mediation practice sometimes now. I'm seeing more and more confidential briefs that sometimes they're really lengthy and they cover every single fact that's involved in the case. So I read a 25, 30-page brief with all their exhibits, could be like 100 pages, and it's all confidential. It doesn't go to the other side. And so it's difficult sometimes then when you do the mediation to know what from that brief I could talk about with the other side because it's all been labeled confidential. I don't know how do you handle that, Debra?
So usually if I can get the brief before a pre-mediation telephone conference, then I can discuss it with the attorney on the phone. And I like to try to talk people out of confidential briefs. I know in certain fields like employment law or sexual abuse, it's more commonplace. But particularly, I've had some plaintiffs' confidential briefs, and I'm thinking, gee willikers, how will the other side know where to set reserves? How will they know what you want and what the issues are? How will you persuade them that your case has this high value? So I think it presents some difficulties for us because if there isn't some sharing and reciprocity to the sharing of materials, how are we going to be able to bring this forward towards a settlement? So I typically will bring it up during the pre-mediation conference, and I'm usually successful because I'll say, well, there's really no information the other side doesn't know or couldn't learn. And
yeah, I think that's good. John, I don't know if you have any thoughts on that.
Yeah, and I agree with Debra to try to persuade both sides to share their briefs because usually I warn them, you're trying to bring the other side to their senses and get a settlement. You're not trying to bring them to their knees, and without giving them the facts and your argument, you're kind of boxing with one hand behind your back.
Yeah, I agree with that. Sometimes I try to encourage, if they think that there's something in it that's really, really confidential, because a lot of times there's the things that I don't see why that should be confidential, but to maybe do a breakout and have that in a little brief so that I just have that. That's easier for me to know what I'm not supposed to talk about to the other side, and it helps me live with my ethical duties not to breach the confidentiality that I have with each party. So that I know this little bit, okay, these are things I can't talk about, the rest of the stuff I can. There are a number of other requirements. I'm not going to go into them all, although I like the fact that they have maintained procedural fairness, which was always one of my favorite things on the bench, to make sure that parties feel like they've been heard. And that's that goes with lawyers and with the parties themselves that are there, and with the adjusters. Let me tell you, I try to make sure that the adjusters feel like I understand what their point of view is and what they feel about a case. And I think that's really important for getting buy-in when time comes to try to get the money up to settle the case. I enjoy that part of the requirement, and I try to keep that in my practice as well. Okay, let's move on to the next one. Disclosure requirements. This is another thing that's a little odd. Arbitrations have really detailed, if you're doing an arbitration as a neutral, you have detailed disclosure requirements. You have to talk about every other time you've ever done any work with these parties or anybody in their firm. It goes on and on. It's in the code. So so there's that. When I was a judge, I had lots of disclosure requirements, but there aren't any that specifically apply to mediators. I just do what I did as a judge. I feel that that's good enough. And it makes me feel that I'm doing my ethical duties to let people know if there's something there that somebody might look at as that I might not be fair and impartial because of it. It's usually a pre-existing relationship with parties or the attorneys. I disclose a lot of the times. I did work with one insurance carrier, a couple of insurance carriers a lot when I was in practice. And if that carrier comes up, I usually tell the other side that I understand them. I used to do work with that company. Things have changed a lot in 25 years, but it's still kind of, I know some of the people, I know the companies, myself. So just to make sure that people know that and they don't think later, well, that judge did work with, that company and they didn't give me a fair shake because of it. So I don't know what you guys do with disclosure issues.
Similar. I think I'll be talking about neutrality and impartiality as mediators. I believe that we want you, the attorneys who are bringing the cases to us, to feel that you're coming to someone who's neutral and impartial and giving your client a fair shake. So to help with that perception, I agree. Oftentimes we'll see people that, for John and myself, maybe they are students, or maybe there have, lawyers on both sides become close friends. So I usually find that I'll tell the other side if I've worked with, like you said, one of the carriers before, or with the people, and then it's their decision. I remember one case where they were trying hard to find a mediator, and I just said, well, I kind of know both sides. I'm friends with both of you. It's fair.
Yeah, and I think it's important to get it out early if there's anything, as Debra mentioned, having taught, in my case now for whatever, 16 years or 18 years at Hastings, I've got a lot of students floating around, and I certainly would not want it to come out halfway through the mediation. Oh, John, remember back when I had your class in 2011 and so-and-so said XYZ, and now it comes out as though I was trying to hide that or conceal it.
Yeah, I think it's good to be open about it. It's nothing goes bad if you're open about any kind of potential issues that are involved in the case. Let's move on to the next slide. I'm going to shift up a little bit, but it's ethically related, and that's the mediation confidentiality and privilege issues having to do with the mediation. We're lucky in California. We have a pretty broad blanket mediation confidentiality rule. The Supreme Court's weighed in on it a couple of times, that it should be broadly construed. And there are a number of statutes that provide broad coverage for maintaining mediation confidentiality. So why don't we move on to a couple of those? Mediators really aren't allowed, with a couple of exceptions, to testify regarding anything that occurred at one of their mediations. That's Evidence Code Section 703.5. No evidence or anything said in, for, during, or pursuant to mediation is admissible or discoverable. That's Evidence Code Section 1119, which is really the big kahuna for mediation. That's the one that everybody points to. It shows up in the case law, and it's really the most important one, and provides the broadest protections. And mediators can't make reports to the court. which is in section 1121. That comes up, you'd be surprised how many times on the bench it would come up. Somebody come back from mediation and they'd be complaining about the other party didn't participate in good faith, and then wanted to get the mediator to write a report saying how bad the other side was. So that used to come up a lot, and I knew this one well, so I just cut that off. Look, you can't do that. The mediator can't. Let's just move on and get your trial date. But it is very clear that the mediators can't be asked by anybody to write a report. Evidence Code Section 1125, a mediation ends and confidentiality ceases to attach. And I think the first couple are very it's the kind of thing that just by your nature you would think that would end the mediation. The last one is a trick though. So, and this is really important to know. If there's 10 calendar days where there's no communication between the mediator and any of the parties, the mediation is deemed finished and confidentiality ends under 1125. A lot of times in my mediations, if you don't get the thing settled the first day, maybe you'll get talk about continuing it for another day. Sometimes you don't have any contact at all with the parties for a period of time, and then they call you up again. Hey, we'd like to get this started again. Can you do a couple calls? I make a point whenever that happens to say that mediation is still in session and that the confidentiality, or mediation is now again, and confidentiality is present so that everybody feels protected. So I think it's important to do.
Hey, Judge Austin, I happened to read one of the questions, and it would be apropos here. And it was, when you were a judge and people completed the mediation, when they then came to a CMC before you, because of the confidentiality, what could they report? For example, the mediation was successful, case settled, or mediation failed. And then what about the amounts, the last demand and the last offer?
I don't think that the last demand and the last offer are appropriate. In Contra Costa, we had the judge was we used to do our own settlement conferences, and there's some ways to go about doing that, even though I'd be trying the case. It's a grand tradition in Contra Costa. They don't do that in most places. But so I'd eventually figure it out what the deal is, because I'd be doing their settlement conference later, so I didn't care about it too much. But I don't think that you can do that. I think that's covered by the mediation privilege, don't you?
Right, but you can just say it failed.
Yeah, you went. We didn't settle, judge. Let me have my trial date. You could do that, or it was successful. Why don't you put everything on hold and vacate the trial date, and we'll get all the paperwork in.
Right. And so let's say you then are at the point of an MSC, you can say what the last demand is and last offer. You just don't relate that to the mediation.
Yes, I think that's fair. Okay, let's move to the next slide. These are some exceptions that we don't really need to go into that. It gets kind of deep in the weeds, and I think my time's about up. So I think maybe if you want to find the exceptions, they'll be in the materials. And this is important. The Supreme Court has recognized that all the statutes are there, and there maybe some bad conduct and bad behavior is going to escape us all. But that's worth it for the broader good of getting these cases settled, getting these people's lives going on, and keeping them out of court with their disputes and finishing things up. So I think that that's the right attitude. Mediation privilege and danger. There's a couple of cases. This is from last year's session. Both of these, AB 924 and SB 42. SB 42 was basically the same as Rule 8.3, but it didn't give mediation confidentiality protections. It didn't get passed, so I think it's good. These both kind of came up in the aftermath of Girardi's situation. There was a whole bunch of bills that were issued. AB 924 also had to do with complaints against mediators and what they would do with that, and it was a complex deal, and it didn't go anywhere either. So I'm thinking that maybe that first foray into trying to chip away at mediation confidentiality didn't work, and maybe we won't see any more for a while. Okay, that's the end of my presentation. Thank you.
I was enjoying it. Now it's my turn.
Well, now I get to enjoy yours.
Okay. Well, I'm going to be talking about legal ethics in mediation settlement agreements and getting into what are lies and what are truths and what we can say. So hold on. It's going to be a fun ride. Okay. Next slide. All right. This is an important evidence code section because it talks about settlement agreements are largely inadmissible, but there are ways that you can fix that. The parties can make it clear that the agreement is admissible or subject to disclosure. That's the main way. The agreement provides that it is enforceable or binding, which most do. All parties to the agreement expressly agree to its disclosure. Or the agreement is used to show fraud, duress, or illegality. So the pro tip mentioned there is you can just make sure to waive section 1123 and then add in some other language in your agreement. Next. Thank you. So this is the fun part of what I get to talk about, and it's lying in mediation. Is it okay to lie to any of us here, the mediators? Mark Twain is famous for his quote, "A man is never more truthful than when he acknowledges himself a liar." And there are three kinds of lies: lies, damn lies, and statistics. So let's get into that. We have California Rules of Professional Conduct, Rule 4.1, which adheres to truthfulness in your statements to others. So when you're representing a client, you as a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless there is disclosure prohibited by the Business and Profession Code, et cetera. So that's kind of what we're going to be talking about for the rest of my presentation is when is it a material fact and when can you just lie? Next slide. So this is the fun part, lies. What if, as a lawyer, you tell me, $100,000 is my bottom line? What do you think out there? Is this a lie? Well, it probably is, because you probably would go lower. If I say, is that it? Okay, well, then we're going to end this mediation. You're probably going to tell me, well, wait a minute. There might be a little bit more room. Let me talk to my client, right? So a bottom line or your top line or your top number, those are considered to be okay. They're like little white lies. Everybody does that. We call it puffery. So when I have you in a mediation and you're telling me this is my bottom line, I'm going to walk, we'll talk about that. There might be some things that we can have you consider. What about authority to settle? Well, that's more interesting. You must tell the truth when you're talking about your authority as an attorney from the carrier, from the client to settle. So the example I'm going to give you is, I had a neighbor of mine, true story, some decades ago, very good lawyer, and he was in trial. So back in the day, I also did insurance defense. Judge Austin did some insurance defense. What we used to do back then, I don't know if you still do, is we would be in trial for the day and we would then come home, and besides preparing for the next day, we would write a report to the insurance carrier saying, these were the parties or these were the experts that testified. Here's what their testimony was. There were some inconsistencies. This is bad for us. This is good for us. And then we'd end the report. So they kind of knew how the trial was going. Back in the day, they used to come visit. Nowadays, they just wait for these reports. So we do this every single night. So this attorney, he would be writing that things were getting worse and worse and worse. So after a week and a half of this, the carrier finally sat up and said, you know what? We better send someone to that courtroom. Maybe we should be settling this case. And so their manager, claims manager, goes to the courtroom in San Francisco, and he finds that Department 21 is locked. And he tries it again, and it's locked. So then he goes to the presiding judge's department to ask about that trial. Turns out the case was never in trial. The attorney who there's many layers of fraud here and problematic behavior. The attorney had been sending billing sheets. You know how you bill a 0.1, which is 6 minutes in the defense world? He was sending billing sheets for like 10, 14 hours a day to the carrier or to his partners. So he had his timesheet issue. Then he was probably golfing because he couldn't be at work. He couldn't be at home. Who knows what he was doing? But it turns out that he had settled the case for more than his authority level. And so he thought that if he just said that we are pretend trial and things are getting worse, the carrier would have given him that amount and then the settlement would be kosher. So he ended up getting not disbarred, but just suspended from the practice of law. And I ran into him at an event and he is now practicing in a different county. But there were so many levels of what he did that were unethical. I just use that as a please have the correct authority to settle when we ask you. The next problematic area is solvency and bankruptcy facts. So oftentimes as a mediator, if either the settlement demand is over the policy, so we're looking at excess, we might be looking at the defendant paying cash out of his or her pocket, or they're underinsured or they need to pay money themselves, then usually during a pre-mediation phone call, I will assess whether they are bringing the defense side an asset protection attorney or a bankruptcy attorney or personal counsel with them so they can disclose their financial picture. Typically, the plaintiff's counsel might send out a declaration of assets or no assets form to be completed, but they need to understand how much money, what is the house worth, is there a homestead exemption, is there some non-exempt money that's not in a 401k, which is protected, maybe it's in a savings account. And so you do have to be truthful when you're giving your facts as to how much money is available so that the plaintiff knows whether to accept or not accept in a settlement. The next slide. Or I should ask, let me ask before we get there, Judge Austin, have you had any situations like that with regard to assets of a defendant and how truthful they are?
Yeah, I think it happens way too much. It happens a lot to the point where they're always saying I'm going to go bankrupt, and then it does happen. And I think it's kind of people who've been in the business for a while, they sort of expect it. And trust but verify, I think, is always an important thing. And I don't know because most of the time it's coming from not necessarily the attorney, it's coming from the party, usually the defendant, who has excess exposure. And good attorneys are very cautious in what they say about their clients' assets if they don't have personal knowledge. And I really respect that whenever that happens, because this is just a constant issue.
Well, that's why if they could bring an asset protection attorney or bankruptcy counsel, then that attorney can say, we have reviewed the documentation submitted by the plaintiff. We've done a title search. We know what's out there. And, hopefully you can trust that asset protection attorney or I have called into a separate, like my officer breakout room on Zoom, both the plaintiff's counsel, defense counsel, and the either personal counsel, bankruptcy attorney, or asset protection attorney, so that they can actually show some financial records on Zoom. They may not want to disclose or give it to them, but at least you can have questions asked. Or if it's a business, you can have their financials up, which has happened to me in a couple of employment cases where the defendant employer didn't have insurance. Because otherwise, how do you know who to trust? How do you know how you can settle it? John, what's been your experience?
I agree. It can get really dicey, especially if you've got a sympathetic plaintiff making the allegations against the defendant.
Mm-hmm. Yeah.
I had one other question regarding bottom line, and this is for Judge Austin. When you were doing mandatory settlement conferences while on the bench, how did you deal with the fact that you were in effect wearing a mediator hat versus the tribunal hat in that situation? And did that ever come up? And that's kind of a tightrope to walk.
I think it is, and I think it's really important when you do those kind of thing, if you're the trial judge and you're doing the settlement conference, to recognize how difficult that process is for the parties, and make sure that they understand from the beginning, look, if this thing doesn't settle, it's no skin off my back, I just do the trial. So it's not like I'm here to force you to settle or try to threaten you or do because I'm going to have power over the case. I make a point of make sure everybody does, and I tried really hard to establish that reputation with the attorneys, because once you start getting like that, nobody wants to have a settlement conference with you anyway. So you might as well be upfront from the beginning that this is not going to, and really mean it. It doesn't really make any difference to me if you don't settle the case. I mean, I like it when people settle, but if it doesn't happen, it doesn't happen. And make sure I never did anything that could be perceived as being a retribution for somebody who was taking a settlement position that I didn't agree with.
Yeah, I've seen judges where they bring the counsel in chambers and they make almost a ritual of taking the robe off and hanging it on the back of the door. And in fact, I've told clients that, he's not doing that just to be comfortable. That's very symbolic right there.
I would say that always made me uncomfortable. They do that in Marin County as well. And when I was a practicing lawyer, I had a judge tell me, well, you should settle because you know how I'm going to rule my motions in limine.
Eee.
So I think it could be problematic.
Yeah.
It could be problematic ethically for the judge too that's doing it. There's a number of canons that come into play. So you really got to watch yourself, make sure that you don't get embroiled and end up doing something that you shouldn't be doing because of the role that you're in. What I would get every once in a while, we had private attorneys that would come in when I was on the bench that did last day mediation. They were volunteers, really good, almost all. But every once in a while, I'd get little back from the attorneys. They were using the courthouse and the fact that the judge was sitting right there, that's going to try the case, to kind of push a little harder than maybe they should to get the case settled. And I was always resistant of that. And I try to calm everybody down and say, no, don't do that. You're just here to get the thing settled. So don't try to put people in a bad posture.
Good. Okay, let's move on to neutrality. So this has always been interesting to me. What is neutrality and how does it differ from impartiality? And I looked up the definition. So in mediation, neutrality ensures the mediator has no personal interest in the outcome, while impartiality means treating all parties equally, fostering trust, and a fair environment for reaching a resolution. So in neutrality, a mediator's sense of disinterest in the dispute and its outcome, not favoring any specific party or outcome. So it's important for us as mediators to create an environment where all parties feel their voices are heard equally, promoting trust and collaboration, which is one of the reasons when Judge Austin talked earlier about disclosures that we want to let parties know if we have had a prior working relationship with another attorney or something, so that we are very careful about perception of neutrality and impartiality. I know that I once was a participant in a mediation where the mediator was talking to opposing counsel about a wedding they just went to the past weekend. Well, that may have been innocent, but it might have been nice to disclose. Certainly wasn't something they might have wanted to talk about in front of me, the opposing counsel, because of that perception. For impartiality, even-handedness is the goal, objectivity and fairness towards all parties throughout the mediation process. So it's important to ensure a level playing field where all parties have an equal chance to present their case and reach a fair resolution. Neutrality and impartiality are crucial and closely related, both contributing to a fair and effective mediation practice. Mediators have an ethical duty to remain neutral and impartial throughout the entire practice. Judge Austin, what do you think?
I like that. I agree. Yeah, I think that's spot on. It's not an easy thing to do because you get an idea in your head about maybe where this thing should go, and to exhibit both neutrality and impartiality is hard to do.
Great. Okay, next slide. So we want to balance confidentiality with transparency in settlement terms. And, it's interesting. I have in my practice as a mediator that defense counsel should send a draft settlement and release agreement to opposing counsel the morning of our mediation, if not before. And the reason for that is I really hate when a case is settled at mediation and then one of the parties wants to bring up confidentiality and non-disparagement terms. I mean, usually in the old days, you gave consideration for confidentiality. You certainly don't wait till last minute. I think that, when you circulate these earlier settlement and release agreements, that is super important in an ongoing case right now involving large habitability claims. I worked on a series of them a year ago, and now there's another series. And one of the learnings, since I did not see the settlement and release agreement that was done a year ago, was the liquidated damages clause. It's there to hopefully prevent violation of the confidentiality and non-disparagement. In this case, that didn't quite happen. So I have been working with the parties to send the settlement and release agreement draft months before this new mediation round. And I said, please agree upon liquidated damages. They are supposed to be a deterrent, so make it painful if one of the parties breaches it. So they are working on that. Next slide. Okay, this is going back to, again, the neutrality and impartiality that we want as a mediator. I think the question under evaluations, do evaluations of a party's case affect the mediator's perceived impartiality? I find this to be extremely interesting. I usually prefer not to give my evaluation of a case because I don't feel that's my role. That's for the parties to decide what is motivating them to settle. Hopefully I have subject matter expertise. And if I am asked by both sides to give a case evaluation, I usually will give a little pushback, but then will go ahead, if it's appropriate, and give them kind of pros and cons that I would be concerned about in front of a jury. Professor Dean, what's your practice with that?
Do you do that in caucus, Deborah, or do you do it in front of the group? Or do you talk to counsel if they would like you to give a reality check to one client or the other?
It's more with their permission, and it usually is for a reality check purpose.
Yeah.
That's why I usually phrase it in terms of I would have concerns that a jury might find.
Mm-hmm.
You bring up some of the strengths and weaknesses. And you're right, oftentimes counsel will use us appropriately as a mediator to help them if their client's expectations are a little high or crazy, to bring them more into reality, because hopefully they're choosing a mediator who has maybe subject matter expertise, certainly the trial experience, to know where this case might go.
Yeah, exactly. And I think that's why it's so important when selecting a mediator to not just grab whoever happens to have next Wednesday open, and to get somebody with expertise in that particular field who can have some cachet with opposing counsel as well.
Exactly. Judge Austin?
Yeah, evaluations are difficult. I always do it. If I did it, I don't do it in the whole room, for sure. And only after they really ask for it. And it's mostly because they say, when you were on the bench, you used to tell us what you thought it was worth all the time. And so, when we were looking for that, that's why we came to you. That's only when I did it. You know how it comes up a lot? It comes up with when you're doing best case, worst case scenario. Sometimes when the parties are really far apart, you guys do it too. You wait a while, things are kind of slowing down, and you try different things. So I best case, worst case scenario. And then the evaluation, it's not necessarily that you are giving the evaluation. You're like kind of talking them through. What do you think the best case, the verdict would be 100%? What do you think the comparative is going to be? Well, what if it, and then you also offer suggestions. Well, what if it was 25% instead of 50% comparative? What if it was this, and kind of be there to kind of guide the evaluation a little bit and put some structure to it instead of you saying what your evaluation is.
Yeah, well, and Professor Dean and I teach our students to invert. I love that word. So I'll have the defense in a room and I'll say, well, let's invert. What do you think their best day is? What does that look like? And, by the contrary, what is your worst day? And then, we used to write defense reports that said, 5 out of 10 times all defenses or something. Well, what about those other 5 times? And so when you do it in front of the carrier in the defense room, it's pretty effective because we didn't really look at what their best side would be, which is the whole purpose of a mediation is it's going to be some sort of compromise. And the same token in the plaintiff's room, you say, let's invert. What do you think happens if the jury believes XYZ? What's their best day look like? And so I guess it's kind of like an evaluative, right?
Yeah, the whole idea of inverting, that's Warren Buffett's idea on why he's a good negotiator. He takes it from the standpoint of the other side. What do they need to say yes? What is their view of the case? Because we all know as advocates, every case looks like a slam dunk winner when you're in your caucus room before the other side has presented their case. And when I initially did criminal defense work, I would always warn my client, you're going to sound like the worst scumbag in the world while the prosecution is presenting their case for 4 days. And don't let it get you down, because then we're going to present our case and bring the dial back a little bit.
Great. Okay, next slide. This is my favorite part of this ethics lecture is the mediator's proposal. So what do experts say? Apparently, one said, I define the mediator's proposal as the exact point in time where the mediator ran out of skills, or some mediators use the tool of self-importance in a way that says, here, I'll resolve this for you. Or could it be that if more mediators possessed a wide variety of skills and techniques, then the mediator's proposal might just quietly slip away? And then lastly, I like this one. Unfortunately, I think many counsel looking for a mediator's proposal are more lazy than savvy. I think they're absolutely wrong, 100% wrong. Just as a quick definition, in case we have some newer attorneys on this Zoom, a mediator's proposal would be, as a mediator, I will come up with a settlement figure, a number, let's say it's 100,000, and I have to get consent first from both rooms, both parties, and then I give it to them almost at the same time. I'll go into one room and say the mediator's proposal is 100,000. It is open until, sometimes on Zoom, I do it in an hour. Sometimes they need to think about it, or the carrier needs to send it up the chain to get further authority from headquarters. So it might be another 24 or 48 hours or something else. And then I go in the other room, tell them. If one side says yes and the other side says no, there is no settlement. The side that says no does not learn that the other party would have said yes. So this is really nothing lost or no harm here, no foul to do it. The reason I think that it's so successful, and I believe I settle the grand majority of my cases using a mediator's proposal, is that it is a face-saving measure for at least one side. What do I mean by that? Let's say you're the plaintiff's counsel in the room with your client, and your client has said, I am not settling this case for under $150,000. And you know that the risks and uncertainty going to trial, and by the way, the costs are going to go up exponentially that is a small case for trials, that you are better off taking the 100,000 today than putting more money and effort into it, and maybe they come back with a defense verdict. So it allows you to say the mediator, who we selected because she has 42 years of experience in personal injury and 40 jury trials, she has thought this number looked as a good compromise. And then in the defense room, perhaps the defense attorney who has to try the case and the claims rep do not agree on the value, and the defense attorney needs to get more money. You are that new information. You are that new voice that they have selected. She's tried so many cases, even for this carrier, right? That they will then go and get that extra money. So I find that it's very helpful for both sides, and it really succeeds if we have a feeling of fairness and reciprocity and trust that has been built up in both rooms during the mediation itself.
Yeah, we used mediator proposals quite often in collective bargaining, where both sides needed to have, as you put it, Deborah, some cover. And they can say that, look, the mediator has been with us for 6 days now. She knows everybody's arguments, and this is what she's proposing. It's not our proposal. It's not the management proposal. It's not everything we want, but this looks like a reasonable solution. Oftentimes we would have a management team that would go public and say, we're never going to pay retroactive pay till the date of the contract expiration. We're not going to do it. And we would have union leaders saying, we're going to get full retroactive pay, or we're not going to sign the deal. And so you could have a mediator proposal that says there's no retroactive pay, but there's a signing bonus that is suspiciously close to the same dollar amount. Both sides can say they got what they wanted without anybody getting egg on their face.
Judge Austin?
I use them. I end up using them a lot, but I'm always resistant. So I try everything I can think of to try to get the thing done without doing a mediator's proposal. But sometimes it's the only way. They're both set in their ways, and you could tell after a while that what's causing the problem, if it's the client, if it's the attorney, if it's the adjuster who's doing it, and it allows does allow them to save face. I only do it if I know I'm pretty confident based on discussions that both sides are going to accept it.
And I think that's key.
Because it fouls up if that doesn't happen. It really does. Even when you don't disclose if one side says yes and one side says no, because that would ruin the bargaining positions going forward. They all seem to kind of figure it out, because I've come back in on some of those cases and you could tell that they figured out who said, one of them said yes and one of them said no. And it does affect bargaining position, even no matter how you try. It still does.
It's kind of a last ditch type of a thing. As you said, if you're really confident this gets us over the hump, you can go for it, because you've pretty much put your finger on the scale at that point. And it's tough to walk that back.
So it's super interesting that you say it. It's like, being an experienced mediator, you sort of have to read the tea leaves to know exactly what that correct number is. And I let the parties know that this is not my case evaluation number at all.
No, yeah.
Highest number I think I can get the defendants to reach, and the lowest number that you'll take. That is a good settlement. And so sometimes it's not as high as the plaintiff's counsel might want, or vice versa. But otherwise, I won't get that number from the defense, for example. And then they're in a position of maybe 2 weeks later having a trial. So it's a real sweet spot. I was teaching my class, and a very good trial attorney was in there, plaintiff's counsel, and she was telling the class about a mediation she just had. And she said, well, the mediator came in and she said, what would you think about, instead of 450,000, we think about 500,000. She's like, no way, I'm not taking 500,000. I would never take 500,000. And I said to her in front of the class, I said, she was reading the tea leaves. She was getting a pulse on whether you would consider that for me. She goes, really? I said, yes.
Yeah, that's the trick of the trade.
Trick of the trade. Okay, next slide, please. So we're talking about informed consent and settlement agreements. And this is so important. Attorneys must ensure the parties are provided informed consent to settlement terms. And I think, this is one of the hardships, I think, with Zoom. 99% of all of my mediations, and probably yours too, are by Zoom. I know I love doing them in person. I know Judge Austin loves doing them in person just because we're people. And so we want them in Zoom, but it's really hard when the plaintiff is in one room and the attorney's in another, their office. And they can talk, but you have to make sure that they're understanding those settlement terms, because when the case is over, right, that's happening. And so you need to start discussing confidentiality, and non-disparagement early on, so they really understand what that means. We had a case almost blow up because the plaintiff wanted to write a book about his life and include the mediation in it. You can't do that, and he almost backed out. So those terms are key. I think we're talking about ethics. It's really discouraging as a mediator when you see that I've had some in person where the plaintiff's counsel does not have the parties present. It's a multi-party case, like 40 or 50 plaintiffs, and they're not present and they're not calling them in between the demands and offers going back and forth. So, please communicate with your clients and early on with regard to the special terms. Okay, next slide, please. I know I'm almost out of time, so I'm just going to make a comment here about enforceability of mediation settlement agreements. The laws changed so that an attorney can hold it enforceable for the client. So it used to be that if it's changed about 2 years ago, if I sent an email to mediator saying confirmed and each attorney wrote back confirmed, that would bind their client. I think the best practice, however, is if we can have a settlement and release agreement at the mediation. I know ADR services, my staff people are so gracious, they can have it docu-signed by the plaintiff right there. So I typically will have, we settled the case, the defense attorney will send a draft of the SAR over to the plaintiff's counsel by email. They'll approve it or make changes and send it back. And the final version will go to my ADR services staff, who will then have it docu-signed to plaintiff via their cell phone. And then we all get copies at the end and we are done for the day. Literally, it's all wrapped up and there's nothing better than that.
Yeah.
Go ahead.
And one of the challenges, Deborah, is if you just end up with a bullet point settlement that's going to be documented, a day or two later by counsel, momentum is a big deal in mediation. And the parties may feel very motivated to get the deal done and to settle. And then they're going to go home. They're going to talk to their neighbor. They're going to sleep on it. They're going to think it over. They're going to wish, they're going to drive by the car lot and think that if they had gotten 10,000 more, they could have gotten the top of the line model with the settlement money. And the use of DocuSign and similar software to get the deal finalized right then and there, I think, is critical.
Judge Austin, any comments?
No, I agree with that. It's anything you could do to get it really to make the parties aware how important it is to see if you could reach an agreement right then. And you got to have it all together to do that so that it can happen and not have loose ends, because loose ends means that the next day everything falls apart. And I've seen it happen a lot of times. Well, it takes you another full day to get back to where you just were.
Yeah. Okay. I'm going to skip to the end and just say thank you because we're at that mark anyhow for the break. So those will be in your materials and I think we're good. Thank you.
Thank you, Deborah. I am going to pull our slides down for just a few minutes here. I know that 2 hours is a long program, so we wanted to give everybody about a 5-minute break here about the midway point. So we are at about 5:10, so we'll resume back at 5:15 for John on his segment about professional responsibility. And then we will have some wonderful discussion with our speakers. So everybody come back in about 5 minutes. And speakers, you're welcome to turn your cameras off or your audio off if you would like to take a pause as well.
Now we can answer questions. You're on mute.
You think I know that I muted myself? It's just
really. Every Zoom mediation, one person's on mute.
Okay. All right. Well, thank you. Regardless of practice areas, all lawyers spend a huge percentage of our time negotiating, whether it's settlement agreements in a litigation context or personal services contracts, discovery protocols, collective bargaining agreements, plea bargains, severance agreements, IP licensing. Regardless, the list goes on. And neutrals that serve as facilitators or mediators are also negotiating. Even arbitrators are frequently thrust into the role of a mediator in pre-hearing settlement talks. So we're all negotiating all the time. And so our challenge as lawyers is to competently represent the client and seek a favorable result when negotiating, while involving some level of posturing and bluffing and puffing, which Debra alluded to, while honoring our obligations, which Judge Austin noted, to the legal system and to those other parties, to be honest toward them. So today we're going to focus pretty much on my section on the ABA model rules of professional conduct, and currently 49 jurisdictions plus DC follow the model rules or something very close. They were first adopted in 1983 and were last seriously amended in around 2018. In 2018, California also revised its rules of professional conduct, and they now follow the format and most of the substance of the model rules. So we're going to focus on two key areas, truthfulness and confidentiality, because both of those are real minefields for lawyers in the area of negotiation. And I believe that all of you watching the webinar today are honest people and you're honest lawyers. I'm sure of it. The reality is none of you are going to embezzle client money. You're not going to forge a signature on a document. You're not going to lie to a judge. Those cases are few and far between, and they usually make the newspaper. But what I hope will become clear is during my 47 years as a lawyer, we have moved from ethics, air quotes, to professional responsibility. And the applications of these professional responsibility rules are not necessarily intuitive. And that is the challenge for all of us. And it's particularly true, as I said, in negotiation, where some element of puffing, posturing, and, for lack of a better word, lack of truthfulness is not only acceptable, but it's expected. And the challenges for advocates are fairly obvious, but the challenges for neutrals are just as critical. Parties choose mediation and arbitration because ADR is typically faster and more expeditious and more efficient than the civil courts. But confidentiality is also usually a pretty important driver. So an ADR provider that sustains a data breach can see their reputation shredded overnight. So I also want to add, before we even start, that the professional responsibility rules are absolutely not keeping up with technology. And for an illustration of that, all you have to do is look to artificial intelligence. There's virtually no professional responsibility guidance related to artificial intelligence. On the one hand, you have Kirkland & Ellis, the largest law firm in the world by revenue, and they are not only embracing artificial intelligence, their managing partner has said he thinks that they will eliminate 1/3 of paralegal and associate positions by 2030 as a result of AI. And they've taken the additional step of investing in an AI software developer. And the other side is Skadden Arp, that not only prohibits use of AI, but they are very concerned about AI and confidentiality. So you've got two diametrically opposed approaches and no real guidance from any of the regulatory authorities. So my goal today is just to point out some of the potential landmines and alert you to the red flags that are out there so that you can address these. The key one, and we've touched on this a little bit already, is that you have to be an advocate on behalf of your client and use reasonable diligence within the law to achieve their result. And you also have a duty of honesty and candor to others. And Rule 1.6 deals with duties to the client, and we'll talk about that in some detail here in a moment. Rule 3.3 is duties to the tribunal, the court, or the arbitrator. And Rule 4.1 is duty to third parties. Next slide. Judge Austin talked about Rule 1.1 competence, and that includes not just changes in the law, but also changes in technology And that is a really important area. There has been a lot of enforcement action related to people not understanding the technology they're using. How many of us have sent an inadvertent reply all when you meant to send it to only one person? I've gotten documents during contract negotiations where the opposing counsel has sent it to his or her client for their comments, and it comes back to me. And as soon as I open the document, you can see the edits on there where he didn't take out the comments and edits from the client, or he outlined or redlined some of them. So understanding the technology you're using is critical. Next slide. Rule 1.6, I'm going to spend quite a bit of time later in my presentation on Rule 1.6, but it's very important. It's a fairly new rule. California adopted it in 2022. A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to client information. Next slide. Rule 3.3, both in California and the ABA rules, is your duty to the tribunal. And this is an ongoing duty. So if you become aware that you or your client made a false statement of law or material fact to the tribunal, you have an ongoing duty to correct that through the conclusion of the proceeding. So if you've got a client who is making inappropriate statements to a judge or an arbitrator, you have an obligation to correct that. Next slide. 4.1, this is the duty to third parties, and this is the material fact obligation. You cannot make a misstatement of a material fact to a third party, whether it's in a contract negotiation or anywhere else. Next slide. And the key, as Debra pointed out, is what's material. And the rules allow differences of opinion as to value, quality. These are the best widgets on the market. This is the best house in Seacliff. Whether you're going to file suit, whether you're going to litigate to conclusion, whether you have a good alternative to a settlement, whether the other party has a poor alternative to a settlement. We're going to kill you at trial. We're going to wipe the floor with you. Bottom lines are generally not material. And the reason I had asked Judge Austin that question is oftentimes a mediator in caucus will ask you, okay, counsel, what's the most your client can put on the table to make this case go away right now? What's the most? I'm trying to help you here. What's the most? And bottom lines are not a material fact. You have no obligation to be truthful to the mediator. And the reason I asked Judge Austin about the whole thing with the robe and whether you're in the role of mediator or judge, oftentimes before an arbitration starts, counsel get pulled aside by the arbitrator. Okay, is there any basis for getting this thing settled? Is there anything we can do to try to resolve this? I've been pulled into chambers by judges before we start to impanel a jury. Counsel, what can we do to get this case done? You're going to tie up my courtroom for 2 weeks. The bottom line there is not material because you're talking to the judge in the role of a mediator. Puffing and bluffing are generally okay, but are you bluffing about something that is clearly material? Next slide. The example I like to use is you're negotiating to sell a parcel of land down near Bakersfield, and the only thing on this land is rocks, but there's a lot of oil rigs in the area. You tell the potential buyer, it's a great piece of land. I think there's oil on it. That's not a material misrepresentation unless you've got a report that says there is no oil. That's a misrepresentation of a material fact there. And the challenge here is you're almost benefited by the Forrest Gump rule. By being smart enough not to get the report, you can at least say, well, I think there's oil there. Once you get the report that tells you there's no oil, if the other party asks, you've got to be truthful. And if you're not, you've just misrepresented a material fact. Next slide. California Business and Professions Code 6068 has a kind of an ominous clause to it. It says it's the duty of an attorney to do all of the following, and among others, it says to maintain inviolate the confidence and at every peril to himself or herself to preserve the secrets of his or her client. It's kind of a frightening comment, but you have a real obligation to preserve your client's confidential information, whether it's that they don't have an alternative to making this sale. Maybe they're trying to sell something and this is the only game in town and they've got to make this deal. And disclosure of the fact that they have no other options could completely undermine their leverage, and it could put them in a very dangerous position. So you have a real obligation, if you're a California lawyer, to protect client confidentiality. Next slide. Vega versus Jones Day is sort of the seminal case in California. And in this case, a buyer bought an entire corporation lock, stock, and barrel. And while it was in escrow, before it was finalized, the seller went out and basically they factored some of their receivables. They went to a financial company and they got cash in return for some of their receivables. The attorney for the buyer became aware of this and called counsel for the seller and said, hey, I understand you guys just did a factoring deal. Anything I should know about? And counsel for the seller said, it's just a routine factoring deal, except it wasn't. It had a clause in there for toxic stock. And basically what happened is if the cash on hand got below a certain point, the amount of money owed to the financial company was converted into stock at an outrageous rate, like 100 shares per dollar, so that the factoring company instantly became the new proud owner of the company. And that's exactly what happened. The buyer ended up having paid money for nothing. In court, in the resulting lawsuit, the Court of Appeals said, if the attorney for the seller had simply turned over the 350-page document and said to the buyer's attorney, knock yourself out, go ahead and read it, they would have been fine. If the attorney for the seller had said nothing, had said simply, I don't want to talk about it, that would have been fine. But he misrepresented, and the buyer's attorney had no way of finding out the information. They didn't give him access to it. So he relied upon the representation. So you got to be very careful if you're making representations and not giving the other party a chance to verify with their own information. Next slide. Okay, bluffing and puffing. CalBar has a formal opinion on that, and it's cited there. And next slide. The ABA has pretty much exactly the same thing. And this covers overstatements, understatements as to the strengths, weaknesses of your position in litigation, your opinion as to the value of your case, the value of a product, estimates as to quality, whether you have alternatives. Well, if you won't sell them to me for $3, I'm going to go buy them from somebody else. Or I'll sell my products to someone else when you don't have any other options. All of this is considered bluffing and puffing. And as Debra said, most people don't put much stock in any of that. Next slide. Okay. So some of the bells, Judge Austin and Debra jump in on this, a one-sided agreement. If you end up being a counsel or mediating a one-sided agreement. I had a friend who was representing a party in a divorce, and the husband, soon to be ex-husband, was an attorney, and they were down to fighting over who's going to get the house and how much and so on. And one day the husband came in and said, look, I just want to get this wrapped up. She can have the house. she can have the house. I'm walking away from it. Let's get this wrapped up this week. And the reason was he had accepted a teaching position at a university back east. He wanted to get this wrapped up, and he and his new love wanted to pack their bags and move to Boston. So they ended up signing a one-sided agreement. The wife got the house. It was the biggest asset, and so on. The husband moves with his new love to Boston, and that lasted about a year, after which he decides to come back, wants to reopen the whole thing, can't understand how the attorney could have allowed him to sign a deal like that. I wasn't in control of my senses. I was in love. You should have stopped me. He didn't get very far, but you have to protect yourself with something like that. Can we go back to the other one just for one moment? We have a culture in the Bay Area and Silicon Valley, fake it till you make it. And as Elizabeth Holmes found out in Theranos, that can be problematic. If you've got a client who's maybe wildly optimistic about the qualities of his or her product, if they're being very difficult or demanding, that can be a challenge for you. Make sure you're listening for those bells. A walk in the woods. How often has a mediator taken you and opposing counsel out in the hallway for a private chat? Or you've taken opposing counsel out for coffee saying, let's see what we can do here. The walk in the woods can be very problematic. It can alienate your client if you're not explaining to them exactly what you're doing and why. But it can also be very helpful. I was involved in a negotiation where, for the love of God, we could not understand why the vice president of labor was being so hostile to us. He wouldn't even agree on when to break for lunch. And he had normally been a rational person. And it turned out, after talking privately to a opposing counsel, unbeknownst to us, the CEO had announced his pending resignation to the board, and the VP of labor was one of the candidates for the position. But he was being sort of undermined by one of his competitors, the CFO, who was telling board members, this guy is a tool for the union. So he needed to show how tough he could be to the union. Well, we can play that game. We increased our ask dramatically. We went public with our astronomical ask, and then he was able to beat us down to what we wanted all along. And he could show how tough he was for the union. No names mentioned, but he became CEO of that airline. Another problem that comes up, the helpful client. Would it help my case if I remembered it this way or that way, or if I lost this damaging email? And Debra's already talked about the unrepresented, self-represented, or underrepresented party. And that can be a real challenge for a mediator as well, dealing with an underrepresented party where you've got a really experienced attorney on one side and a fairly inexperienced counsel on the other. And he or she is about to get steamrolled. And that can raise some real ethical challenges for the mediator.
You know, speaking of the difficult client, it comes up both with client and with the adjuster sometimes, where the attorney wants to talk to you and they're having problems internally. It's good to know, but sometimes I feel uncomfortable a little bit when I'm kind of plotting with the lawyer against their client or plotting with the defense attorney. I kind of have to back off after that after a while. I just feel like that's not something that
it's kind of a tightrope to walk.
It's a very difficult one as either when I was a judge or as a do a settlement conference or as a mediator, and it comes up a lot. It's not like just a one-off. That kind of thing does happen, and I try my best to not get too embroiled into the situation. Well, I'll see what I could help with. Let's see if we could redirect and then kind of go in and do things, but not kind of actively I don't know, actively get too much involved in whatever dispute going on between the people in the room.
Yeah, it's tough. Next slide.
Say usually you think that the attorney and the client are on the same page and they're working together to move it forward. But it was in another sexual abuse case that was in person in our Oakland offices. And the plaintiff's counsel was very interested in the settlement, getting the money, the settlement. And someone had asked me, by the way, on the questions here today about the non-monetary terms. And oftentimes non-monetary terms can be very important. And in that case, the victim, very lovely young woman now at 19 years old in college, she really wanted an apology. The perpetrator had died, but his daughter was there, and she just wanted her to listen for a moment about her constellation of symptoms that she's going to live with the rest of her life as a result of his actions, and maybe an apology. And that's all she wanted. She would have taken the money that was on the table if she could get the apology, and the attorney wasn't listening. So as a mediator, I'm sitting in there and I'm hearing both of these things going on. And, it is a tightrope, but finally I say, you know what, maybe we can first look at this non-monetary term, hold that thought to the attorney on the money. And so we went and we took care of that and came back and got it settled. But sometimes it's hard to do that balancing act.
Yeah, they're not always united.
No.
Yeah. And sometimes as attorneys, we're so focused on money and we think it's always just about money. And often it's not just about money. Okay, just a kind of a quick synopsis. It's not enough to just be honest. You're going to have to stay current on the PR rules as they're evolving. These AI rules, for example, are going to be coming out in the next 6-8 months, hopefully. And who knows where they're going to settle on that. The technology is absolutely outpacing the public professional responsibility rules. Up until 2018, the rules related to cloud storage, they were applying the rules related to misdirected faxes, which it's like a square peg in a round hole. It was crazy. Wow. And you simply can't rely on an every third year 1 hour video. And with that, I want to...
Excuse me, John, what's a fax?
Yeah, what's a fax? I don't even have my fax thing set up anymore. Yeah. I mentioned earlier Model Rule 1.6c and California Rule of Professional Conduct 1.6c. And this is an absolute minefield. This one says an attorney shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to client information. Next slide. And the official comment says you not only have to take reasonable steps, but you also have to prevent inadvertent or unauthorized disclosure by the lawyer, yourself, or persons who are subject to your supervision. And that's where it gets really dicey. And this rule just came in 2022. It's a new rule in California. It's now in about 38 of the states. They all have something very similar to this. And nobody really knows where this is going to go. There is a case in New York that is one that I'm trying to watch and follow carefully. A chemical company sold one of its chemical plants to a buyer, and it was done very quietly and discreetly. They have all the documents written up, both parties represented by very reputable, nationally known law firms. And they were reviewing the final documents, and one of the paralegals at the seller's law firm decided to work from home. And then during the day, she decided to go to a coffee house, and she used the public Wi-Fi. And as you might imagine, ultimately it got leaked to the media. And what happened was the buyer unilaterally increased the purchase price by $13 million to send a signal to everybody, we're making this deal happen. We are going through with this sale. Okay, so the sale closed. Everybody got what they wanted. And you would think they would live happily ever after, but not so fast. The seller's attorney went after the buyer's attorney went after the seller and the seller's law firm, saying, you owe us the $13 million. They made a settlement, presumably got the $13 million. But then they also filed with the New York bar. And the partners involved in this are now facing disciplinary action, despite the fact that every employee at the law firm, when they're onboarded, had to watch a 1-hour video on client confidentiality and cybersecurity. They had to watch a repeat every year in January. They had to sign a form that they had watched the video. This paralegal had been there 6 years. She had done all that. The problem was during the investigation, New York Bar discovered that nobody was following the rules, and members of the law firm, attorneys and paralegals, were accessing data and documents in public restaurants, coffee houses, and so on. So it is very important that you understand you've got to train and supervise anybody who reports to you. Next slide. The factors that will enter into what is reasonable are case specific, and that includes the cost, how salacious the information might be, the cost of any safeguards, and so on. One example is biometrics. Any of you who bought a new smartphone, tablet, or laptop in the past year, all of them now come with biometrics, either facial recognition or a thumb scan. And I did this in a recent CE class. I asked people to raise your hand if you bought a device in the past year. Keep your hand up. Now raise the other hand if you disabled the biometrics. Half the people that had bought a device had disabled the biometric. And in the cost-benefit analysis, if the biometric comes with the device, that's going to be a tough sell. Another thing would be, have you implemented cybersecurity updates and software updates when they are made available? Next slide. We like to think that cybersecurity and data breaches all happen from cinder block buildings in North Korea or the Gulag or northern Russia, but the reality is a survey by the Association of Professional Responsibility Attorneys, the people that represent lawyers in claims like this, 65% of all data breach claims resulted from stolen laptops, this physical theft of the device. A whole bunch of other cases resulted from dumpster diving, the failure to shred or the failure to properly dispose of documents. And the FBI says law firms are the #1 target for data breaches. At the law school, I'm always fascinated. Third-year students get so excited that they get a job offer, and one of the perks, the firm is going to give them a $3,000 Apple gift card to use to buy a new phone and a laptop for when they start work. And that's wonderful. But what is the policy when you leave that firm? Do you have to bring it in and get it wiped and deleted? What is the policy? Because if you just take it and drop it off at Goodwill when you leave the firm, it may have confidential data on it. And most firms have a wipe and delete policy, and a lot of them simply don't follow that policy. This can be an enterprise risk for your law firm and a license risk for you. Next slide. So your best protection, use modern encrypted devices. Make sure you update. Use reputable security software. Consider Cisco Meraki, Google Authenticator, Microsoft Authenticator, Monster Iron, some of these programs that limit access to your device. For $40, you can put a thumb scan on an old laptop or an old desktop. Don't use outdated software. Windows 7 was released in October of 2009. Microsoft stopped supporting it in January of 2020. 2 years ago, a survey by the American Bar said 40% of the law firms with 10 or fewer lawyers are still using Windows 7. And virtually every law firm data breach was at some way, shape, or form linked to Windows 7. Not that there's anything inherently wrong with it, but it's been out for a long time, and it's not being monitored or updated by Microsoft. Next slide. Cloud storage. Everybody's moving to cloud storage, but who owns the data? A few years ago, several big cloud storage companies thought they would get smart, and they tried to change their contracts to provide that they own the data. That got resisted, but law firms need to recognize that cloud storage is not just a cost decision, it's a professional responsibility decision. 70% of all the cloud storage companies that began operations in the last 10 years are gone. What happens to that data on those servers when the company files bankruptcy? What if you change suppliers? What proof, what guarantees do you have that the former cloud storage provider is going to wipe and delete everything off the servers? Next slide. Bottom line is your license is at risk above and beyond any respondeat superior liability for damages. You do have a duty to train and monitor your staff and anybody who reports to you. That includes, support staff, paralegals, summer law clerks, anybody. It includes expert witnesses, that real estate expert that uses his 20-year-old laptop, all of them. Next slide. So protect yourself, your clients, and your reputation, and take the necessary steps. You can check Troy Hunt's site, Have I Been Pawned? PWNED. It's a free site. Will tell you if your data or your law firm's data is out on the dark web. It's a quick, easy way. Nice to do occasionally with even your personal data. Next slide. It's no longer enough to just be honest. That's not enough. The professional responsibility rules require that you know of the rules and follow them and stay updated. Next slide. And as I said, this Rule 1.6c has been adopted since May of 2021. We don't really know how aggressively it's going to be enforced here in California or anywhere else, but it should raise some real concerns with lawyers. Next slide. The data breach can be catastrophic for a law firm. It can be catastrophic for an ADR provider. Again, an ADR provider, you are providing a confidential resolution service, and that may be one of the real drivers for why people are coming to you. And if they can't trust you to maintain confidentiality, they will find someone else. It's an enterprise risk. Next slide. Preet Bharara was the U.S. Attorney for the Southern District of New York, and as a result of his location, they did a lot of SEC enforcement and cases involving stocks and mergers and things like that. Lawyers cannot continue to be blissfully ignorant of the implications of technology. That's very, very true. Next slide. And this is just a quick reminder, and I'll wrap up. Years ago at a college campus, the professor was administering the final exam in the classroom, and everybody went to the classroom, and it was on one corner of the campus. And he divided the class in two, and then he told them, I'm going to let you walk in 5-minute staged release across the campus to the opposite corner, and the final is going to be in that classroom. It's going to take you 15 minutes to walk. I'm going to allow you 20 minutes. But if you get there after 20 minutes from when I release you, you will not be allowed to take the final. You will fail the class. So the first group leaves, and as they're walking, and he told them exactly what route to take, as they were walking, they passed a body laying on the trail, all bloodied up. 90+% of the people stepped over the body and continued on to the classroom. Okay, the second group was getting ready to leave back in the first classroom, and he handed them silently a little index card. Do unto others as you would have done unto you. And then once again, he released them in 5-minute increments. 85% of them stopped to render aid to the victim. Now this has been repeated thousands of times. You can Google it. There's thousands of examples. They've repeated it with Israeli medical students with an excerpt from the Islamic Quran. They've done it in Egypt with nursing students with an excerpt from the Judeo-Christian Bible. They've done it with every conceivable religious group as well as atheists. They've across every group. The second group, almost always 85+% stop to render aid. And you can draw your own conclusions from that. The conclusion I draw is just thinking about ethics turns your ethics radar on. I'm not suggesting that you have to put the rules of professional conduct on your nightstand and read them every night before bed, but waiting every 3 years for a video doesn't do the trick. So keep in mind, these rules are evolving as we speak. And next slide. You can't put your head in the sand. The rules are not intuitive. It's not enough to just be honest. And with that, I'll turn it over to Debra and Judge Austin if you have any comments to jump in.
This is Kate. I wanted to hop back on this screen and just note that we do have our speakers' contact information in the slide materials if you have any follow-up questions for them. But in our remaining time, we have about 10 minutes left. First, I wanted to offer Judge Austin and Debra if you had any comments on John's section about professional responsibility there.
I need to go check my laptop.
Yeah.
I want to get that pond.com.
Yeah.
That's a scary thing. I've been taking just a few classes I've taken recently in the tech stuff, and it's just disturbing and difficult. And you know, not Debra, but you and I, we're old. This is hard to figure these things out. And I'm seeing it all around me. I'm getting briefs now, mediations that are AI generated briefs that I know I could tell because of the formatting that I know the company that's doing it. You can see it, and really amazingly good AI generated briefs that must have been looked at by the lawyer and fixed up. But I mean,
one would hope, yes.
but it's all over the place. In practice of law, it's everywhere, and it's going to get more and more and more. There's no way that the world of, the changes in the professional responsibility rules take 5 or 6 years to get through. And it's a hard, I don't know how that's ever going to happen.
And right now with AI, I mean, nobody knows what the rules are. It's like, take your best guess. And you could see with Kirkland and Skadden at opposite extremes, and everybody else is kind of somewhere in between.
I would just say as the last comment that as we are evolving and getting more tech and more AI, I'd ask everybody that's on here to take a step back and do something that's very old-fashioned. Pick up the phone and call your opposing counsel. Meet them for lunch. It still happens. And, I can't tell you how many cases that you could start your negotiations over a very pleasant lunch as a starter or over the phone. I think we've gotten so far away from, when we talk about civility in the law, from just doing that. We're too into emails, and emails, they don't show your tone or your intonation, or they can be misread as to the intonation. And so I would just encourage everybody, as we're evolving in society, to just start connecting. That's why I love in-person mediations. Someone did ask online, I think 98%, Katie would have the statistics, are probably by Zoom. Most of the time they're equally or not more so effective, but I just like the human contact that you get from the rapport building, from long-term relationships with your opposing counsel. Those of us that are speaking on this Zoom come back from an era where this was something we would do all the time. We see each other in court on case management conferences. We would have our file, we would talk about it. So I would say, let's go old-fashioned. Let's start doing some just common sense things like picking up the phone.
Yeah.
Somewhat the opposite of old-fashioned, but I wanted to ask you about social media. John has touched on a lot of kind of online presence with security. Have any of you seen any kind of ethics-related issues arise around use of social media in mediation, or just issues in general? I'll start with you, Debra. You seem like you have a coy smile there.
Right now, I think sometimes, the ethical line on solicitation, when I've seen some on social media, it's a slippery slope. I think when we talk about, I've seen it we have confidentiality in an employment situation, and then the defense firm has gone online to the plaintiff's Facebook page and seen some derogatory stuff said about the former employer. So, the problem is that we, as the attorneys and mediators, don't control the party's social media access. And it's broad. It's not just, the old Facebook or Instagram or LinkedIn or X or anything. It's just such a broad stretch that, and it also goes to say that defense counsel always looks at or pays someone to look at the social media of the plaintiff. And that's well before they probably have hired an attorney that says, watch what you're putting on social media. So there's some cautionary tales out there for sure.
I'm concerned about confidentiality and mediation on Zoom, where it's harder anyway. They still do it when you're in person. Somebody's got their cell phone on record in their pocket, but it's a lot easier to record the Zoom, even when ADR Services has it disabled. We can't record it, so nobody can by pushing the buttons on Zoom do it. But they're still just set up their right off camera. They got their phone
on a shelf.
yeah and in the middle of confidential caucuses, and it's very scary, that part of it. I try to remind people at the beginning of mediation that it can't be recorded, it can't and you can't use this for any purposes when we talk about confidentiality, but you can't, people get carried away and their emotions get going, and they do things that they would think better of if they weren't in that situation, and it can be bad.
Mm-hmm. I see Deborah was writing some responses to some of our Q&A, but I would love to see John and Judge Austin, what do you think about the old saying that a successful mediation is one where everybody walks away unhappy?
Or at least not thrilled with the result. And they have to come in with the idea, it's not beating them senseless. You're going to have to be willing to compromise. And I think we all try to set that tone at the start, that we're here to try to reach a settlement. And that doesn't mean beating them into accepting everything you're demanding. That can get tough.
I like it better when they all walk away happy. And
That's
it happens a lot of times.
Yeah.
Like, everybody's happy. Boy, got over with. Oh, and you just see it. You see it in their face at the end. They've all been tough guys, and then you get to the end, and thank you. So glad this is over.
I never want to see my lawyer again. Yeah.
Exactly. Yeah. It happens way more than you think it does.
I think you're right about that. I think people do walk away happy, but I do like to use the old adage that if I do my job well, each side walks away unhappy. The defense pays more than it wanted to, the plaintiff takes a little less than they wanted to. And because it's just good for setting the tone and the expectations that they're going to have to compromise somewhere. But you're right. When we do it really well, both sides are just elated. They have resolved it. They're not looking at trial. You're right.
They may not be.
Especially when it's one that they think is not going to settle. There's no way this is going to settle, and then it does. Boy, people get happy. It is.
I think one of the best compliments I had recently was the claims rep said, yesterday we had such an acrimonious mediation, and this one, slides were just so professional and pleasant, but it settled, and it settled like in an hour and a half. So that was right.
They were scared of you.
Never.
Which is a sign that getting back to the old kind of professional civility is it's not just good for your health, and it's good for your mental health. It's good for getting cases settled. I mean, it really is. For any attorney involved. I mean, I see it too. When you get one where the parties are on their speed, they treat everybody with business, with sense and sensibility, and they get in there and the case gets settled. But it does a lot easier than when they needlessly cause conflict.
Yes.
And with our 1 minute left, if each of you could give your younger practitioner self one piece of advice about balancing this zealous advocacy with all of these ethical requirements and all of these kind of real goals for resolution, what would you tell yourself?
Wow. Huh.
I had my first boss told me, he used to say, always remember this isn't going to be your last case. And I think that's a good one. It's been in my head ever since. And I think that's a good advice, because your career is going to be long. It's going to be great. Whenever you're tempted to step over that line, just know, wait, this isn't going to be my last case. So I got a long life and career ahead of me. I'm going to make sure I do it, and I can look myself in the mirror.
And I just simplify it and say, you're in it for the long haul, so build those long-term relationships. This should not be a one-off. and then you'll.
It's a small community. You'll see the same people over and over again. And a pilot told me once, don't eject over the area you just carpet bombed. They won't be happy to see you.
All right, words to live by. I like it. That does bring us to 6 o'clock here. Thank you, everybody, for joining us this afternoon.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.